Question 1. A California notary public is asked to notarize a document that has several blank spaces. What must the notary do? A. Advise the signer on the legal implications of the blank spaces. B. Fill in the blanks with "not applicable" or "not applicable" before notarizing. C. Refuse to notarize until the signer fills in the blanks or lines through them. D. Proceed with the notarization, as the content of the document is not the notary's responsibility. Answer: C. Refuse to notarize until the signer fills in the blanks or lines through them. A notary must refuse to notarize an incomplete document because it presents a high risk for fraud, as information could be added later without the signer's consent. The notary's duty is to ensure the document is complete at the time of signing, which is accomplished by the signer either filling in the empty spaces or striking a line through them. This core principle protects the public and the integrity of the transaction by preventing subsequent alterations. Think of it this way: your seal on a document with blanks is like co-signing a blank check. Question 2. When a credible witness is used to identify a signer, the notary must administer an oath or affirmation to the witness. What is the primary purpose of this oath? A. To prove the witness is a resident of California. B. To have the witness swear or affirm to the identity of the document's signer. C. To confirm the witness understands the contents of the document being notarized. D. To verify the witness's own identity document is valid. Answer: B. To have the witness swear or affirm to the identity of the document's signer. The primary purpose of administering an oath to a credible witness is for them to formally attest, under penalty of perjury, that they personally know the signer. This sworn statement becomes part of the official record, providing a strong basis for the notary to establish the signer's identity when no acceptable ID is available. The oath underscores the seriousness of the witness's role in the notarial act, making them legally accountable for their statement. Remember, a credible witness is essentially a human ID card, and the oath is what makes their testimony official. Question 3. What is the maximum fee a California notary may charge for administering an oath for a deposition and issuing the certificate? A. $15 for the oath and $15 for the certificate. B. $30 for the entire service. C. $7 for the oath and $7 for the certificate. D. There is no set fee for deposition services. Answer: B. $30 for the entire service. California law sets a specific, combined fee for the services involved in a deposition, which is a formal, sworn testimony taken out of court. This fee is $30 for all services rendered, which includes administering the oath to the deponent, the person testifying, and completing the required certificate of deposition. This is an exception to the standard per act fee structure. To keep it simple, just remember that a deposition is a special, all-inclusive $30 service. Question 4. A notary's official seal is lost, stolen, or damaged. What is the first required action the notary must take? A. Order a new seal from an authorized vendor immediately. B. Notify the Secretary of State by certified or registered mail. C. File a police report in the jurisdiction where the loss occurred. D. Inform their bonding agency in writing. Answer: B. Notify the Secretary of State by certified or registered mail. The first and most critical step upon realizing your official seal is missing or unusable is to immediately notify the Secretary of State in writing. This formal notification is required by law to protect against fraudulent use of your seal and to officially document the issue. While filing a police report or ordering a new seal are also important steps, the legal obligation is to inform the commissioning authority first. Always think of the Secretary of State as your first point of contact for any major changes or problems with your commission status or tools. Question 5. In California, a notary public is legally authorized to certify a copy of which of the following documents? A. A birth certificate. B. A power of attorney. C. A university diploma. D. A United States passport. Answer: B. A power of attorney. California law strictly limits the types of documents for which a notary can certify a copy, a process called copy certification. A notary is explicitly permitted to certify a copy of a power of attorney and can also certify copies of entries from their own official journal if requested. Notaries are prohibited from certifying copies of vital records like birth certificates or public records like court orders, as certified copies of those must be obtained from the official custodian of that record, e.g., the county recorder. The key takeaway is to know that copy certification authority is very narrow. If it's not a power of attorney or your journal, you likely can't do it. Question 6. If a signer cannot write their name and must sign a document with a mark, what is the specific procedure a California notary must follow? A. The notary must write the signer's name next to the mark and have one witness sign the document. B. The signer must make their mark, and the notary's signature as the official witness is sufficient. C. The signer must make their mark, and two witnesses must sign the document, one of whom writes the signer's name next to the mark. D. The notary must refuse the notarization as a full signature is required. Answer: C. The signer must make their mark, and two witnesses must sign the document, one of whom writes the signer's name next to the mark. The procedure for a signature by mark is highly specific to ensure the validity of the signature and prevent fraud. The law requires two witnesses to observe the signer making their mark, typically in X. One of these witnesses must then write the signer's name next to the mark, and both witnesses must sign the document themselves as witnesses. The notary then proceeds with the notarization, noting the signature by mark in the journal entry. The rule is simple: a signature by mark always requires two witnesses to be valid for notarization. Question 7. A notary completes a jurat on a document. What, specifically, is the notary certifying? A. That the signer's identity is authentic and they personally appeared. B. That the signer personally appeared, was identified, signed the document in the notary's presence, and took an oath or affirmation. C. That the signer acknowledged executing the document for its stated purposes. D. That the contents of the document are true and correct. Answer: B. That the signer personally appeared, was identified, signed the document in the notary's presence, and took an oath or affirmation. A jurat is a notarial act that certifies four key things: the signer appeared before the notary identified the signer signed the document in the notary's presence, and the signer swore or affirmed that the statements in the document are true. This is different from an acknowledgement, where the signer can sign beforehand. The key phrase for a jurat is, subscribed and sworn to, or affirmed, before me, which highlights the dual requirements of signing and swearing in the notary's presence. Always remember, for a jurat, you must watch the person sign the document. Question 8. A notary who is not an attorney is advertising their services in Spanish. Which of the following phrases is prohibited? A. Servicios de notario. B. Notario público. C. Ayuda con documentos notariales. D. Certificación de firmas. Answer: B. Notario público. California law strictly prohibits a notary public from using the phrase notario público in advertisements because it is a literal translation that is misleading to the public. In many Latin American countries, a notario público is a high-level attorney with extensive legal authority, which is not the case for a U.S. notary. Using this term can falsely imply the notary can provide legal advice, which constitutes the unauthorized practice of law. To stay compliant, always use the state-approved phrase, "I am not an attorney and cannot give legal advice about immigration or any other legal matter." Question 9. When must the notary's journal entry for a particular notarial act be completed? A. At the end of the business day. B. Within 24 hours of the notarization. C. At the time the notarization is performed. D. Before the end of the week in which the notarization occurred. Answer: C. At the time the notarization is performed. The law requires that all information for a journal entry be recorded at the time of the notarization to ensure accuracy and completeness. This contemporaneous recording prevents errors or omissions that could occur if the notary waits until later. Recording details on the spot, including the signature and thumbprint, if required, creates a reliable, chronological record of the notary's official acts. A good habit is to complete the journal entry first, before you even stamp and sign the document, to ensure it's never forgotten. Question 10. A notary changes their business or residential address. How many days does the notary have to notify the Secretary of State of this change? A. 10 days. B. 15 days. C. 30 days. D. 60 days. Answer: C. 30 days. A notary public is required by law to inform the Secretary of State of any change to their business or residential address within 30 days of the change. This requirement ensures that the Secretary of State has current contact information for every commissioned notary, which is essential for official communications and maintaining the integrity of the public office. Failing to provide this notification in a timely manner can result in fines. A simple way to remember is to link this 30-day rule to other common life events, like updating your address with the DMV. Question 11. What is the primary difference between an acknowledgement and a jurat? A. Only a jurat requires the signer to be identified. B. For a jurat, the signer must sign the document in the notary's presence. C. An acknowledgement requires an oath, while a jurat does not. D. A thumbprint is always required for an acknowledgement but not for a jurat. Answer: B. For a jurat, the signer must sign the document in the notary's presence. The most critical difference between these two common notarial acts is the timing of the signature. For a jurat, the signer must physically sign the document while in the presence of the notary, after taking an oath or affirmation about the truthfulness of the document's contents. For an acknowledgement, the signer may sign the document beforehand and then appear before the notary simply to acknowledge that the signature is theirs. Here's a quick memory trick. Jurat starts with J, like a judge, and you must swear and sign in front of a judge. Question 12. A California notary public is presented with a document written in a foreign language. The notarial certificate itself is in English. What should the notary do? A. Refuse to notarize the document because the notary cannot understand its contents. B. Notarize the signature, as the notary's function is to certify the identity of the signer, not the content of the document. C. Require a certified English translation of the document to be attached before proceeding. D. Advise the signer to find a notary who is fluent in the language of the document. Answer: B. Notarize the signature, as the notary's function is to certify the identity of the signer, not the content of the document. A notary's primary duty is to verify the identity of the signer and witness the signing or acknowledgement of the signature, not to understand or validate the document's contents. As long as the notary can communicate with the signer and the notarial certificate is in English, the notary can proceed with the notarization of the foreign language document. The notary is certifying the notarial act itself, not the text on the page. Just remember, your job is about the signer and the signature, not the document's details, provided you can properly communicate with the signer. Question 13. Upon resignation of a notarial commission or at the end of a term without reappointment, what must a notary do with their official journals? A. Destroy them after a period of 1 year. B. Keep them for a period of 10 years for their personal records. C. Surrender them to the clerk of the county where their current oath is on file. D. Mail them to the Secretary of State's office. Answer: C. Surrender them to the clerk of the county where their current oath is on file. California law requires a notary to protect the public record by delivering all notarial journals to the county clerk's office where their oath of office is filed within 30 days of their commission ending. This ensures the journals, which contain sensitive public information, are preserved and remain accessible for legal purposes. The county clerk becomes the official custodian of these records once a notary's commission is no longer active. Think of it as returning your official equipment to the proper local authority when you are no longer on duty. Question 14. Which of the following is a required element of a California notary's official seal? A. The notary's home address. B. The state seal of California and the notary's commission expiration date. C. The date the notary's commission was issued. D. A telephone number for the notary. Answer: B. The state seal of California and the notary's commission expiration date. A California notary seal must contain specific, legally required elements to be valid, including the state seal of California, the words, Notary Public, the notary's name as it appears on the commission expiration date, the commission number, and the county where the oath is on file. The expiration date is a crucial piece of information, as it informs anyone relying on the notarization of the notary's authority at that time. Always double-check that your seal has all required elements to avoid invalidating a notarization. Question 15. A member of the public requests a copy of a line item from a notary's journal. Which of the following is true? A. The notary must give the person the entire journal to look through. B. The notary must refuse the request, as the journal is confidential. C. The notary must provide a plain copy of the requested line item and may charge a fee. D. The notary can only provide a copy if the person presents a subpoena. Answer: C. The notary must provide a plain copy of the requested line item and may charge a fee. While a notary's journal contains private information, it is also a public record, and any member of the public can request a photostatic copy of a specific line item. The notary must fulfill this written request by providing a copy of the single entry, covering up surrounding entries to protect the privacy of other signers. California law permits the notary to charge a fee of up to 30 cents per page for making this copy. Remember, you must protect everyone's privacy while still complying with a proper public request for a specific entry. Question 16. A notary is asked to notarize a document for their spouse. The document is a deed of trust on a property they own together. The notary should: A. Notarize the document, as notarizing for a spouse is always permitted. B. Notarize the document but refuse to charge a fee. C. Refuse to notarize because the notary has a direct financial interest. D. Ask another notary in the same office to perform the notarization. Answer: C. Refuse to notarize because the notary has a direct financial interest. A notary public is prohibited from notarizing a signature on a document if they have a direct financial or beneficial interest in the transaction. In this case, since the notary co-owns the property, they are a party to the transaction and would directly benefit, creating a clear conflict of interest. While notarizing for a relative is sometimes permissible, it is never allowed when the notary themselves will gain something from the transaction. The rule is simple: if you benefit from the document, you cannot be the notary for it. Question 17. In California, a thumbprint is required in the notary journal for which of the following documents? A. An employment eligibility verification form, I-9. B. A living trust document. C. A deed affecting real property. D. A vehicle title transfer. Answer: C. A deed affecting real property. California law mandates that a notary obtain a right thumbprint in their journal for any notarial act involving a document that affects real property, such as a deed, deed of trust, or quitclaim deed. This requirement also applies to powers of attorney. The thumbprint serves as a powerful biometric identifier that helps to deter real estate fraud. An easy way to remember this is to think, if the document is about land or gives someone power over land, I need a thumbprint. Question 18. The venue section of a notarial certificate indicates: A. The county where the signer resides. B. The state and county where the notarization took place. C. The location where the document will be filed. D. The state where the notary's commission is active. Answer: B. The state and county where the notarization took place. The venue, which appears as State of California, County of __________________________________________________________________________________________________________________ establishes the geographical location where the notarial act occurred. The notary must fill in the name of the county where they are physically standing with the signer at the moment of the notarization, regardless of where the signer lives or where the document was created. This detail is legally important as it confirms the notary was acting within their jurisdiction. Always remember to fill in the venue based on your physical location at that exact moment. Question 19. A notary is presented with an identification card that is expired. According to California law, what is the maximum length of time the ID can be expired and still be acceptable for a notarization? A. It cannot be expired at all. B. It can be expired, as long as it was issued within the last 5 years. C. It can be expired, as long as it was issued within the last 10 years. D. It cannot be expired by more than 30 days. Answer: B. It can be expired, as long as it was issued within the last 5 years. California law allows a notary to accept an identification document that has expired, provided it was issued within the last 5 years. This rule recognizes that people may not always have a current ID but still possess a recently issued government identification that can reliably be used for identity verification. The ID must still meet all other requirements, such as having a photograph, signature, and physical description. So, the key timeframe to remember for an expired ID is that it must have been issued within the past 5 years. Question 20. If a notary's commission expires and they do not obtain a new one, how long must they retain their notarial journals? A. They must immediately surrender the journals to the county clerk. B. They must retain the journals for 10 years from the date of the last entry. C. They must destroy the journals to protect the signer's privacy. D. They must retain the journals for 7 years, then destroy them. Answer: A. They must immediately surrender the journals to the county clerk. The correct action for a notary whose commission has ended, whether by expiration, resignation, or revocation, is to surrender all journals to the county clerk where their oath of office is on file within 30 days. This rule ensures the continuous, secure preservation of these official public records. The 10-year retention rule applies to the personal representative of a deceased notary, not to a notary whose commission has simply ended. Think of it as a mandatory return of state property once your term of service is over. Question 21. A proof of execution by a subscribing witness can be used when A. The principal signer cannot appear before the notary. B. The document requires 2 signatures and only 1 signer can appear. C. The principal signer refuses to provide a thumbprint. D. The principal signer's identification has expired by more than 5 years. Answer: A. The principal signer cannot appear before the notary. A proof of execution is a specific notarial act used when the person who signed the document, the principal, cannot personally appear before the notary. Instead, a subscribing witness, a person who watched the principal sign the document or heard the principal acknowledge their signature, can appear before the notary on the principal's behalf. The subscribing witness must be identified and take an oath that they witnessed the signing. This act is a backup method but is not allowed on documents affecting real property, like deeds of trust. Question 22. What is the standard term of a California Notary Public Commission? A. 2 years. B. 4 years. C. 5 years. D. 6 years. Answer: B. 4 years. A California Notary Public Commission is valid for a term of 4 years, beginning on the date specified in the commission certificate. Notaries must keep track of their expiration date and begin the reappointment process well in advance if they wish to continue serving without interruption. This 4-year term is a foundational piece of knowledge for any California notary candidate. Remembering this simple fact is crucial for managing your own commission properly. Question 23. A notary attaches a loose acknowledgement certificate to a document. What must the notary do to ensure the certificate is securely associated with the correct document? A. Staple the certificate to the front of the document. B. Write a description of the document on the certificate. C. Use a seal embosser to crimp the certificate and document together. D. State on the certificate that it is attached and have the signer initial it. Answer: B. Write a description of the document on the certificate. When a loose certificate is used, the notary must include language on the certificate that clearly identifies the document it pertains to, preventing it from being fraudulently attached to another document. This is typically done by noting the type of document, the date of the document, and the number of pages. For example, this certificate is attached to a last will and testament dated January 1, 2025, containing 3 pages. This creates an inseparable link between the notarial act and the document it validates. Question 24. A notary's willful failure to properly maintain their journal is punishable by a civil penalty of up to A. $500. B. $750. C. $1,500. D. $2,500. Answer: D. $2,500. The law holds notaries to a high standard for maintaining their official journal, as it is a critical public record. A notary who willfully fails to discharge their duties related to the journal, such as not recording required information or not protecting it from loss, can face a significant civil penalty of up to $2,500. This steep penalty underscores the seriousness of journal-keeping responsibilities. Always treat your journal with the utmost care, as it is the official evidence of your notarial acts and your primary defense against liability. Question 25. A notary public has a disqualifying financial interest in a transaction if they are named in the document as A. Witness. B. Agent. C. Trustee. D. Attorney in fact. Answer: C. Trustee. A notary is considered to have a direct financial or beneficial interest in a transaction if they are named as a principal party, such as a grantor, grantee, mortgager, or trustee. As a trustee, the notary has a fiduciary responsibility and a direct role in the management of the assets involved, which constitutes a clear conflict of interest. While other roles might be acceptable, being named as a party with control or ownership interest in the document's subject matter is strictly prohibited. The easiest way to remember this is, if the document gives you power, property, or money, you cannot be the notary.